Welcome to the SEA Centre's new podcast, Perspectives. We are a New Delhi-based think tank, and this podcast is a platform for our researchers to discuss technology policy issues in an accessible format.
Did the UK decide to end the right to privacy for everyone across the globe? Can the UK even do that? Why are there news reports highlighting the end of privacy, and why is everyone so scared about privacy coming to an end? So, for context, in 2022, Apple rolled out this advanced data protection encryption measure for iCloud services, wherein they basically said that they would not have access to any user data which is collected on iCloud. Now, the UK recently approached Apple with an order asking for access to data stored on iCloud services. Apple decided to not give them access and not create that backdoor. So, what does that mean? What is ADP? And what are we going to do about that from a privacy perspective?
Yeah, so on the question of what is ADP, I think it's interesting to trace it historically as to how we actually got here. So, as you said, before 2022, iCloud backups weren't encrypted. So, essentially, your photos, documents, whatever you were storing on iCloud was accessible by Apple. And by extension, if law enforcement requested for it through a legal order, Apple would share that data, right? Apple wanted to actually go a step further than this, and there were certain proposals that even images stored on device would be scanned. So every image has a hash code, and there are certain identified hashes which relate to child sexual material and things of that nature. So the idea was that we're going to look at the hash of each photo you have, match it with certain pre-identified hashes, and then see if you have CSAM. Now, Apple said that this was a privacy preserving measure, which also helped law enforcement clamp down on what is obviously a major problem in terms of child sexual abuse. But there was a lot of pushback from the privacy community and from civil society because they said that essentially this does amount to creating some sort of a backdoor into encryption on device. And it will probably be extended beyond just CSAM by the government. They'll start asking for access to it. So Apple took all of this into consideration and say, hey, you know what, we're not only going to not introduce this feature of on-device scanning, we're also going to extend encryption to your cloud data. So whatever passwords, whatever documents, whatever health-related information you're storing on the cloud will be accessible only to the user. Even Apple themselves can't access the information because the encryption keys which are necessary to decrypt this information is always with the user. And I think now what the question is coming on is what the UK has actually asked Apple to do, how it's responded, and what the broader ramifications of this are.
Right. So I'll take the first part of it, right, which is exactly what's happened in the UK. So for context, the UK has this law called the Investigatory Powers Act, which was passed in 2016. It's an intelligence law. Now, in February 2025, the Washington Post broke a story saying that the UK government has sent a technical compatibility notice under this act to Apple. This notice basically asked Apple to provide them with backdoor access to encrypted data on iCloud for law enforcement agency purposes. The idea being we need this for security, etc. But of course, if data is encrypted, like you said, not even Apple can access it, and the entire idea is to preserve privacy. So complying with this request would basically mean breaking privacy. And under this framework, Apple would technically have no choice but to comply, because what they can do is they can maybe appeal if they don't agree with this because they have reasons they've introduced ADP. But basically, because they were left in a bind of either complying with this or risking non-compliance, they decided to simply withdraw ADP from the UK. This order, it should be noted, this order was actually extraterritorial in application. So it wasn't just about providing access to UK users' data. It was a global one, and it's global because the Act gives them that power. But that's the situation we're in right now, where Apple has this order. As a result, it's withdrawn a key feature protecting encryption and privacy, and that's why the furor that Chhavi talked about.
Right, interesting. And I actually have a few questions based on what you said, and either one of you could sort of weigh on this is, firstly, is there any good faith way of actually complying with this order without providing a backdoor? Is that sort of the only way Apple can do it? And does providing a backdoor open it up just to the government, or can other threat actors also come in and use it? The second question I have is, how does an order from a UK government authority extend to citizens globally? And does this not entail a conflict with other privacy legislations or perhaps other data sharing agreements that the UK has with other governments? And finally, what are we looking at? How are we looking at this in the context of India? Do we have any similar provisions? Does the fact that the UK has gone ahead and done this set a precedent for the Indian government to do something similar? Is it something it even wants to do?
Right.
I think it would be the creating a backdoor would be an only option for Apple, and there aren't really any ways around it because it's either you give users privacy protection or you don't. And once government has access to that channel, there's nothing stopping anyone else from also gaining access. I think that is a major concern here as well. Just once that backdoor is created, a number of different people, individuals, organizations will also have the pathway to access it potentially.
Yeah, exactly. So, creating a backdoor, and this has been noted by experts on privacy, on civil liberties. They basically said there's no way to, gain access to encrypted information without making users more vulnerable to threats by malicious actors. And coming to whether the UK really had a choice, I don't really think so because this is a very stringent intelligence law. So what they've tried to do, I think, is comply with it in the most proportionate way they can. It's also important to note they can't actually come out in public and say what the contents of this notice are, whether they've even received it. Even the UK Home Office hasn't officially said anything about this, right?
Yeah.
So they're not allowed to under the law. They can't disclose that they've received such a notice. They can't talk about its contents. So given the kind of opacity around how this framework operates, I think they've done what they could very proportionally. So although this order is global, they've tried to currently only withdraw ADP from the UK.
Yeah.
But like you said, that still raises concerns because the application of the order is still global. So firstly, have they even complied with it? That's kind of an open question because the order is wider. Secondly, yes, it does raise conflicts both with agreements with other countries as well as data protection laws. So agreements with other countries, I think a good example is the US Cloud Act agreement with the UK. So the Cloud Act basically allows for exchange of information between law enforcement agencies, but Cloud Act agreements between the US and the UK and other countries don't permit mandatory decryption of data, which is essentially what this technical compatibility notice is asking for. And the US's Director of National Intelligence, Tulsi Gabbard, has also pointed out concerns with this, and she said the US is going to look into whether there's been a breach of these agreements. And even when it comes to privacy laws and those conflicts, in fact, when this law was being deliberated in the UK Parliament, Apple raised concerns that it could involve violations of the GDPR to comply with this, right? Because you do have obligations related to security measures. They also flagged similar concerns around Cloud Act conflicts. So, whether these orders really allow them to comply with privacy laws and agreements is an open question.
Right.
And even in the Indian context, right, we have had marches towards data protection. We've had an act that was passed in 2023. Even when it comes to end-to-end encryption itself, the IT rules in 2021 had a provision which mandated traceability of the first originator of information, which basically meant that if I sent a message and then it's, being circulated to other people, there should be a way that the service I've used is able to identify me as the person that originated that message. But if you look at end-to-end encrypted apps like, say, WhatsApp and Signal, because they use E2E, they won't be able to know it's me.
Right.
So this would essentially involve, again, creating a sort of backdoor and breaking E2E. Because of this concern, WhatsApp, for instance, has challenged the constitutionality of this provision before the higher judiciary, and that's still pending. So that's still out.
Right.
And again, because this order is extraterritorial and it could give the Indian government, again, some sort of impetus to relook at this issue with, a little more rigor and scrutiny. That's also a fear that many other privacy advocates have called for, saying you have governments like the Five Eyes who have historically pushed back against end-to-end encryption. And now this creates an incentive for them to come in and make similar demands. So how is Apple really going to balance this? Because for now they've got away with a narrow implementation, but maybe it's going to be trickier in the days to come. And even with regards to our data protection law, there are a couple of obligations which get, thrown into question. The first is our Data Protection Act requires companies to implement reasonable security measures so that their consumers are safe. And end-to-end encryption, like you also pointed out, has a big role to play in keeping communications private.
Right.
Now, what does it mean if I, as a business, have to withdraw end-to-end encryption because I'm compromising the privacy of my users, I'm creating vulnerabilities because malicious actors can come and take advantage? So that means a company is now possibly liable in case something goes wrong under our framework.
Right.
And in addition to this, we also actually have an angle of data localization, which has come in through draft rules under our Data Protection Act. Our draft rules basically require certain kinds of personal data to be stored within India. There are a couple of provisions on that. Now, again, the idea is to ensure that law enforcement agencies can obtain access to this data because, typically it's tough for them to negotiate agreements with other countries. Process is not streamlined. But again, if such data is stored in an encrypted format, the mere fact of it being stored in India isn't going to give them an advantage.
Right.
So again, complying with this may involve some sort of decryption measure that needs to be taken. And what we're seeing with Apple and ADP is that a business may actually consider withdrawing these privacy protecting features when they realize the writing's on the wall. And is that where we want our framework to go? I think probably not, right?
Yeah, I think there are two very interesting trends that are emerging from this conversation. The first, obviously, is the inherent sort of conflict between encryption and national security. In that, encryption is something that is necessary for protecting personal communications. And given that in most of these jurisdictions that we're talking about, right to privacy is recognized as some sort of a fundamental right, if not fundamental, at least statutory right that individuals have. And given that we're talking mostly about personal communications, I have the right that my personal communication is limited to me and the person I'm talking to. And encryption is a great way of ensuring that. At the same time, there are clear instances where governments may need access to this sort of information to deal with, terror threats, to deal with human trafficking, things of that nature. So how do you balance that is a really interesting conversation, and one we're probably going to see play out in different jurisdictions moving forward. As you said, the Five Eyes countries, which has Australia, New Zealand, other countries and members, they're probably likely to follow suit as well and follow the UK's example. So it'll be interesting to see how that plays out. And the second broader trend, which is not necessarily related to encryption, but which is related to regulation and its impact on product features, is that companies are actively choosing to either withdraw features or delay upcoming features in response to regulatory activity, right? So in the EU, we've had multiple companies, including Google with Gemini, and Apple with Apple Intelligence, and I think even ChatGPT with certain multimodal features that they've put on hold specifically for EU users because of concerns with the EU AI Act. And maybe moving down the road, we're probably going to have fragmented sort of feature provisions and feature sets that are differentiated across countries. So the fragmentation of the internet, of course, is something that's been discussed considerably over the last few years, the balkanization of it, where it's going to splinter into these small groups where the kind of internet I'm seeing in India is very different from the kind of internet that I have access to, say, in the US or in Russia or China. Maybe this is also going to happen on a feature level with products and with services that are available too. So if I'm in the US, I do have ADP, but if I'm in the UK, I don't have ADP. And it's going to be very interesting to see how companies navigate this differential sort of regulatory requirement and fragmentation that's on the anvil.
Yeah, I mean, what I'm hearing is basically you go too far, even if your measure is well intended, you go too far, you could lose on both innovation and privacy, right? And so that's bad for businesses and consumers. So again, there's a need for a calibrated approach to address all of this. And different countries will try and strike their balance according to what seems right to them. But we need to wait and watch before we take more extreme steps and learn from actually what's happened in the UK around what can go wrong.